The U.S. Supreme Court rules in favor of former President Donald Trump in his appeal of a Colorado ballot disqualification. That applies to Colorado. In all likelihood, it will apply to other states as well.
The Supreme Court not only decided that that was unconstitutional, they did it in a unanimous fashion, 9-0. The Supreme Court has announced their decision in the case of the Colorado Supreme Court trying to circumvent the presidential election and remove Donald Trump from consideration. 4 people in black robes deciding not just for everybody in the state of Colorado, but because of the way the Electoral College works, this affects every single American. And those 4 authoritarians didn't want you to be able to vote for Donald Trump. The Supreme Court not only decided that that was unconstitutional, they did it in a unanimous fashion, 9-0. Here's how MSNBC reported the story today.
The Supreme Court issuing a ruling on the Colorado ballot case. I want to go straight to Ken Delanian, who is outside the Supreme Court with this decision. Ken, what do we know?
Good morning, Anna. We've learned that it was a 9-0 decision ruling that Donald Trump can be on the ballot in Colorado and other states. Justices during the oral argument seemed very skeptical of the idea that one state could decide for the nation whether Donald Trump was an insurrectionist and was therefore disqualified under this 150-year-old provision. Now we know that there was not a single justice who held that view. So there were no dissents to this 9-0 decision ruling that Donald Trump can remain on the ballot in Colorado as voters go to the polls tomorrow during Super Tuesday, and also in Maine, where there had been a decision to disqualify him from the ballot. And this ruling, we understand, has the effect of prohibiting other states from attempting to do so. And that really reflects what we heard from both liberal and conservative justices during the oral arguments, Anna. For example, Elena Kagan confronting the plaintiffs, essentially saying, your problem here is that you're arguing that one state can decide for the nation who can be president, and no justice was willing to go along with that.
He seems kind of sad, doesn't he? Like, who kidnapped your puppy, Ken? Come on. Oh, no, we're just reporting the facts here, just the facts. Yeah, this 9-0 thing is huge. It's huge for our country. My God, if this were 6-3, only the Republicans voting one way or the other, or 5-4, we would have still sort of been dealing with the fallout of people like Elie Mystal or Jeffrey Toobin or like Alexandria Ocasio-Cortez screaming that the Supreme Court is broken and then they're partisan and they need to pack the court or disband the court. You know, the way insurrectionists who hate democracy talk or certainly hate our Constitution. The fact that Justice Roberts, Chief Justice Roberts, was able to rally a 9-0 decision here is incredibly unifying around what should be a layup here, a slam dunk, frankly. Of course, one state can't decide these things. Of course, this shouldn't have been able to stand for various reasons, not just the constitutional separations of power and the role of states in electing a federal position, especially like the president of the United States, that is very unique in how it uses the Electoral College to determine the outcome. But more importantly, and most fundamentally, Donald Trump has never been convicted or even accused, for that matter, of insurrection. So it was impossible for the Colorado Supreme Court to be able to do this, unless, of course, you're an activist leftist. In the name of protecting our institutions, protecting our norms, and protecting our democracy, which, of course, we don't even have a democracy. We use democracy to select our representatives in this constitutional republic. But in the name of protecting all of those things, the left in this country, led by Joe Biden and led by the activist media, they have been motivated to tear down every institution and rewrite or bust apart all of the institutional norms that we have had in this country for over 200 years. That's the irony here. And finally, some cooler heads prevailed. Finally, some sanity. But if you watch the coverage here, you'll see that they weren't very sane about this. Let's watch a little bit more of how MSNBC reported the news, and then we'll show you some of the analysis.
And Lisa, you are looking through, we have our our Lisa Rubin here with us. As you look through this decision that was just put on the website there at the Supreme Court, what stands out most to you besides the fact that this was a 9-0 decision?
It was a 9-0 decision, Anna, and the decision was decided on the grounds that Congress, not the states, has the power to enforce Section 3 of the 14th Amendment. Still, you have 4 justices concurring in the judgment, meaning they agree with the result, but also concurring separately and saying that the way that they disagree with the majority or the per curiam opinion is that they don't feel that they needed to decide that Congress is the exclusive enforcement mechanism. Both Justice Barrett, who is concurring only for herself, and then Justices Sotomayor, Kagan, and Jackson, concurring separately, say they don't need to decide anything more than this is not a right that belongs to the states, but all 4 of them casting doubt on the idea that the exclusive mechanism of enforcement here is congressionally enacted legislation. That's important because one other way that you could find that someone is disqualified is through, for example, a federal court ruling, or you could find that someone is an insurrectionist through their criminal liability. So there are a number of different ways that I think these justices are raising Section 3 could have been enforced. And yet the per curiam decision says not only does the power not belong to the states, you have to have Congress act affirmatively in order to disqualify someone from the ballot.
Yeah.
Thank you for
So, and again, incredibly important that Chief Justice Roberts, despite some of the concurring opinions, and it was noteworthy that the 4 women justices all determined another path potentially on this as well. Roberts was able to get them all in a room and say, okay, but what can we all, 9 of us, agree on here? And he found that. And it's huge. You know, you talk about Joe Biden claiming that he's going to unify this nation and bring us together and find, trust me, on this Thursday's State of the Union address, Mr. MAGA fascist, you're undermining our Constitution, you're undermining our norms, you're racist because you don't want to give water to people who are standing in line to vote, Jim Crow on steroids, makes Jim Crow look like Jim Sparrow, all that stuff. That guy this Thursday is going to be Mr. Healer, Mr. Bonder, Mr. Unifier, Mr. I'm reasonable, I can reach across the aisle. Let's figure out what we agree on. Work with me, I'll work with you. That's what you're going to see because it's an election year. But for all that bull that he feeds you on a regular basis, this guy, he's done nothing to try to unify us. Chief Justice Roberts just did more to unify this nation around some basic constitutional norms than Joe Biden has ever done. We do have Donald Trump's reaction to this, as he stated on Truth Social, and that says everything. Big win for America. It really is. And I just want to be clear, you don't have to be a big supporter of Donald Trump to see that this is a win for America. Because anytime the Constitution and basic understandings of how this country is supposed to work is upheld, that's a win for all of us. You realize what would have happened if this was allowed to stand. What would happen every 4 years? States would figure out a way to prevent another candidate from being on the ballot. And then we'd have a complete mess. Frankly, it would be the undermining and undoing of the Electoral College. It would actually hand to people who hate the Electoral College and hate the Constitution another reason to try to move to a national popular vote, which would also be a disaster. Anyone who's sane and reasonable and actually has a head on their shoulders sees this decision for what it is, and even more importantly, sees what Michigan and Maine and just recently a traffic court judge in Illinois has been trying to do. They see it for what it is, which is left-wing extremism writ large in an authoritarian move to keep your voice silent. Anyone with a sane, rational head can see that, which means, of course, Keith Olbermann doesn't see it. Keith Olbermann is the opposite of sane, rational, and logical. And the nutbag Keith Olbermann says the Supreme Court has betrayed democracy. Think about what kind of twisted, addled mind you have to reach the conclusion that the Supreme Court saying that a state can't keep somebody off the ballot and they want ultimately the voters to have the final verdict on something. that that's anti-democracy. See, that's what the Supreme Court said today. You know, you think that Donald Trump is an insurrectionist, even though he's not even been charged with it, let alone defended against that charge or prosecuted in a court of law? You think he's an insurrectionist and he has no business being president of the United States? Let's let the voters decide that. That's literally the democratic process. But if you're a lefty like Keith Olbermann, it's a betrayal of democracy to let people's voices be heard. You have to have an advanced degree from some liberal arts Ivy League college, or in Keith Olbermann's case, Cornell, to reach a conclusion like that. Its members, including Jackson Kagan and Sotomayor, have proved themselves inept at reading comprehension. And collectively, I'm actually doing it like Keith Olbermann. And collectively, the court has shown itself to be corrupt and illegitimate. It must be dissolved. So, to protect democracy, America, and the Constitution, we have to dissolve the Supreme Court. And this guy is a hero. This guy is a hero. This is where they are, though. And it's times like this where it's really instructive to go back and see how these people first reacted to the Colorado State Supreme Court's decision back in December. So this was sort of an emergency appeal that was made to the Supreme Court, right? In December, late December, right before Christmas, the Colorado State Supreme Court decided, those 4 justices decided, that Donald Trump will not be on the ballot for the primary or for the general election. And so there was an emergency appeal to the Supreme Court. The arguments were made in January, and now we have the decision today on March 4th. So back in December, what was the reaction? Well, let's look at our friends over at MSNBC and see the cool, reasonable, legal analysis that they provided.
So it's a great question, Mika, because there are numerous states. Minnesota, I think, is the best parallel because they held a similarly serious proceeding, but the state Supreme Court in Minnesota took the decision away from the trial judge and decided as a matter of law that they would permit Donald Trump to stay on their ballot. So to Secretary Johnson's point about this as a qualification issue, that's precisely what it is. And it's one for every state. And whether we think that that's politically feasible and politically desirable, that's how our system is set up to work. And as students of history, I think, recent history, we have to appreciate that Donald Trump pushed the lie, the myth that Barack Obama was not a natural born American citizen. And
this is beautiful. Hey, we need some constitutional legal analysis of the decision that came from the Colorado State Supreme Court here, keeping Donald Trump from the ballot under the guise of the 14th Amendment. So can you tell us what this is all about? And she didn't even make it a minute until she started waving the Donald Trump is the original birther, and that's the real problem here. What has that got to do with anything? But actually, it's got to do with everything. Because if you hate Donald Trump, you're willing to contort the language, the law, the Constitution, the Magna Carta, basic societal norms. You're able to twist all of it into the shape of an unrecognizable pretzel if that end is met, which is to stop Donald Trump. They are everything they accuse us of being. They are so blinded by their white-hot rage of that man, but again, more importantly, of you. They will never get over you not voting for Hillary Clinton. And so 49 seconds in, she has to make the point about the birth certificate. Now, she'll eventually bring this back around to the question of eligibility on the ballot. But it's obviously a completely gratuitous example because guess what? The first birther in American politics against Barack Obama was actually Hillary Clinton's campaign, who raised the question of his eligibility during the 2008 primary process. Remember when they floated a picture of him in traditional Kenyan garb and referred to him as Barack Hussein Obama? Yeah, that was the Clinton people. And not for nothing, there were some birthers against John McCain because he was born in the Panama Canal territories back in the day. But no, it's got to be about Donald Trump because Donald Trump fries their minds. So here she goes trying to make the case of why Donald Trump should be excluded from the ballot in Colorado based on a speech he gave on January 6th, because originally he wanted to keep Barack Obama from the ballot because he wasn't a natural born citizen, allegedly.
And he did that because had he been successful, that would have meant that President Obama would not have been qualified to be on state ballots. That was, in essence, an effort by Donald Trump to keep Obama off the ballot because of a qualification decision. So the irony, I guess, is a little bit rich that we're at this point with Trump, where under a different provision, the 14th Amendment, his ability to qualify for the ballot is being considered. But at bottom, that's what this is. This is a legal decision, not a political decision. And as far as the law goes, for strict constructionists like conservatives on the Supreme Court who read the law, and if the law is unambiguous and clear, believe that they should follow that law, this is a straightforward decision.
No, it's not. And you can always tell when a legal analyst doesn't know a whole lot about the law and is instead a political analyst who wants to use the law and her basic understanding of the law to make a political point under the guise of legal analysis. You see the dig at Alito and at Clarence Thomas, these strict constructionalists, these originalists. Well, you'll just look at the letter of the 14th Amendment and it's a no-brainer. It's a slam dunk. It's easy. She's either ignorant of what a strict constructionalist is or an originalist is, or she's just lying to you to score political points. Either way, she has no business being on television. If you're actually a strict constructionalist and originalist, you know that the language of the 14th Amendment related directly to the Civil War and has never been employed in the way this court is trying to employ it against Donald Trump. It's never been used against an office like the presidency, and it's never been used by a state against a federal office holder. Also, you would know, if you were a strict originalist and constructionist, that years after the 14th Amendment was passed, specifically dealing with the Civil War, the Congress actually eased up the restrictions on people involved in the Civil War from holding elected office. So she's just a liar or completely ignorant. But it doesn't matter, because at MSNBC, the point had to be made that Republicans and conservatives and Trump supporters are evil, stupid, anti-American hypocrites. And when that's your main focus and your main goal and your entire modus operandi, then you're able to bring yourself to a point where you can say, yeah, and Colorado should be able to decide for the rest of the country whether he's even eligible to be voted for, because we're protecting democracy by removing people from the ballot. And she had more to say, though.
But as so many folks have pointed out this morning, it cannot be a straightforward decision because it involves Donald Trump, who on so many occasions has gotten the benefit of protections of the law, of safe harbors, of due process that lets him delay. Here, though, when the law is being squarely applied to him, he doesn't like that outcome quite as much.
Wow. I mean, again, you have to be a Trump-hating leftist to reach that point where you can say, oh, Donald Trump is just getting the benefit of all of these outcomes when it comes to the legal proceedings against him. Well, that's one way to look at it. Or the other way to look at it is all of the charges that have been brought against Donald Trump are completely politically motivated. You're using the law as a weapon to harm your political opponent. And we actually do have some structure within our legal system still barely standing that protects people from that kind of authoritarian, totalitarian, Marxist sort of attack. That's another way of looking at it. But I got to tell you something. In the immediate on the scene late December analysis of the Colorado State Supreme Court decision to keep Trump off the ballot, what you just saw from that woman is actually not the most outrageous. The most outrageous came from Mara Gay, who sits on the New York Times editorial board. Here's her succinct, sober, completely nonpartisan legal analysis of this decision.
To the Republican candidate's argument that this should be, the voters should have the say and not the courts.
Why are you standing with Confederates who betrayed this country. And this is what they're standing with, is the spirit of those Confederates rather than the Americans who came together after a long and brutal Civil War that was fought to keep the Union together, and clearly saw a threat in ex-Confederates running for office, so much so that they amended the Constitution to prevent those traitors from running for office. That should send a message that our election system, our electoral system, can be used for nefarious purposes against the democracy itself. It's clear. It's clear as day.
You know what? She's right. I think everything that you just heard is clear as day. And it tells you everything you need to know about who's on what side of this issue. And now that you've walked down memory lane, let's just remind you of today's decision. 9-0. Clean sweep. Elena Kagan, Sotomayor, Ketanji Brown Jackson on the side of the Confederacy. Wow. That's a shame on them. Absolutely shame on them. And Mara Gay, the New York Times, Morning Joe, MSNBC, they hate you. I mean, they really hold you in the greatest contempt.